Call the member for Ryde.
Speaker, why do we introduce laws? To respond to community expectations, and if we're good, to get ahead of them. We introduce laws to guide us, to plug gaps, and to help keep people safe. I also believe that there is a role to play in elevating the standard of democracy, elevating the standard of public discourse, lifting society to an elevated place of understanding, embrace, and ambition for one another. It is for this reason that I will support what would otherwise, and on the face of it, be quite a significant deviation from the principle of protecting speech. Because as much as one has a right to speech, the rest of us have a right from speech that gnaws at the fabric of our social tapestry, or worse, subverts the very democratic institutions that enliven and protect the speech of citizens who want to be participants in a civilised society. These citizens may not like every part of our country. They may despise policies of a contemporary government, decry the coverage of our media, hold views that cause embarrassment to their loved ones. But never once do they fail to understand the difference between being a fully paid up member of Australia or a belligerent to its future. I'd like to think that this bill isn't for them. I'd like to think this bill and the way it is interpreted will keep free those who love Australia despite protesting elements of its construct. What I hope this bill will do is send a message to those who don't buy into the very constitution of Australia, to elevate the standard against those in New South Wales who would seek to do the majority harm through the targeted hatred of a minority. I preface with these remarks because I know many members are concerned about the process, wording, and potential for unintended consequences that may come from this bill. These are valid concerns, and ones I share. The reality is, this legislation is being proposed in unusual circumstances. There hasn't been the usual degree of scrutiny of the bill. It was introduced late last night. No legislator, including those in government, could have genuinely thought deeply about the application and implication of its passage. Less hope exists for the judicial and enforcement agencies charged with enacting the law. Even less for impacted stakeholders, and of course those citizens who will be subject to its power. I like that there is an urgent desire to respond to appalling and unquestionably cruel acts of anti-Semitism, but we owe it to the Jewish community to protect them, not offer the promise of protection, unmatched by action in the realm where it truly matters, the public domain. The bill seeks to amend the Crimes Act of 1900 to provide that it is an offence to intentionally incite hatred towards another person or a group of persons on the grounds of race in circumstances that would cause a reasonable person who was the target of the incitement to hatred to fear harassment, intimidation, violence, or for their personal safety, and to provide for the statutory review of the offence 12 months after it commences. The bill proposes to insert, after Section 93Z of the Crimes Act, the introduction of criminal penalties for the incitement of racial hatred. But what is not clear, and what the government has failed to articulate, is how this legislation captures conduct that is not already covered by existing laws. I would be grateful if the Attorney-General in his reply could provide a specific and practical example of a case where this law would take effect in isolation from existing provisions of the Crime Act. In other words, when might a person be subject to prosecution under this law, but not an existing law in New South Wales? And if the answer is unclear, then we must ask ourselves whether this legislation will genuinely afford any of the protections that I know the government is seeking to provide, and whether in fact a more thorough process would have been warranted. Another concern is the potential for this legislation to exacerbate radicalisation rather than to prevent it. We know from international and domestic experiences that heavy-handed criminal sanctions can push individuals further into extremism rather than de-radicalising them. The reality is that locking people up does not always solve the problem. It can entrench ideologies, fuel resentment, and create a cycle of radicalisation bearing martyrs rather than reformed citizens. I personally don't believe those who set out to deliberately subvert our democracy are capable of much reform. However, there are many who have exhibited behaviours that bear some hallmarks of racial hatred who are not necessarily anti-Australia or anti-democracy. While I accept that the legislation does not require one to act upon the incitement of hatred for a crime to have occurred, there must be some degree of consideration given to the intent behind the end goal. It is one thing to be imprisoned for acts akin to treason or sedition, and another to act antisocially online. And that is why I strongly support the review provision in this bill, although I note that 12 months is a long time to wait should it become evident earlier on that there are deficiencies in the Act in practice. If we are to implement such significant laws, we must ensure that they are reviewed rigorously and not only meet but beat this deadline. If we are to truly address the issue of racism and intolerance in our community, then the government must also do more than just legislate punitive measures. We need education and interventionist programs that address the root causes of radicalisation before individuals enter into the criminal justice system. This means investing in community-led de-radicalisation programs, working with schools, faith leaders and youth organisations to provide young people with the tools to critically engage with harmful ideologies. It means ensuring that those at risk of being drawn into extremist movements have alternative pathways to rehabilitation and inclusion, rather than being funnelled into the prison system, where, as I have previously articulated, extremism can flourish. We must also improve early intervention frameworks, training frontline workers, including teachers, social workers and community leaders, to identify the early warning signs of radicalisation and provide appropriate support before it escalates into criminal conduct. If we do not address the underlying societal issues that contribute to the rise of racial hatred, then punitive measures alone will not break the cycle. We must commit to a multifaceted strategy that combines enforcement with education, prevention and rehabilitation, and would again impress upon the attorney to provide how, if at all, the statutory review will inform these solutions. This is particularly necessary in the age of social media. People, ignorant perhaps, but extreme no, have and do fan the flames of division and hatred. It is they, not the subversive types, who this law will most likely deter. However, as we know, deterrence is just one reason for imposing a punishment and must be coupled with measures to elevate understanding and awareness of the broader consequences of such actions. Ultimately, laws are not just about penalties and enforcement. They are about standards. They elevate the expectations of a civilised society. They send a message about the kind of community we want to be. There are individuals in our society who do not believe in democracy, who seek to undermine our institutions, who fundamentally reject our values of tolerance and inclusion. And by doing so, they undermine not just free speech, but free association, movement, and in extreme cases, the liberty of life. These freedoms are each protected by institutions that uphold democracy. And when you attack those institutions, you are in fact undermining freedom itself. That is the paradox at play here, and that is why ultimately we must take a stand. Speaker, my electorate of Ryde is one of the most diverse communities in New South Wales. We do not need a law to tell us to stand up to racism, intolerance, and anti-Semitism. We do that every single day. But what this law does do is send a message to those who have always fought the good fight, even in the face of noisy opposition, that they have the backing of this Parliament, our state's most important democratic institution. And that in doing so, we are right to fiercely defend our principles and proclaim them loudly outward. Speaker, my concerns with this bill remain. The process has been flawed, the consultation inadequate, and the broader implications for free speech troubling. But we must draw a line. We must stand against those who vilify, who threaten, and who seek to erode the values upon which this democracy is built. If we fail to do so, we fail not just the Jewish community, but all communities. And that is the line. I commend with reservation this bill to the House.